Good morning. Thank you very much for making the effort to get out of bed a little bit early this morning and come along and listen to us talk about legal strategy for family wealth and growth. I am Jane Tenquist. I'm a partner here at Myerson and the head of the family team. I'm joined this morning by my colleague Vicky Wong, who's a partner and head of the private client team. She'll be talking about trusts and wealth protection. And my colleague Andrew Brown, who's a partner in the corporate team, who'll be talking to us about family investment companies. Horrible photograph of me, so I'll get rid of that very quickly. So as far as nuptial agreements are concerned, they are a really effective way of protecting non-matrimonial wealth on divorce, and 1 in 3 marriages break down. And so it's really important that if you're a wealthy person that's contemplating on getting married, that you think very carefully about the efficacy of a nuptial agreement to protect non-matrimonial wealth. They're really effective to protect children from previous marriages or relationships, and they limit sharing claims on divorce. And they provide clarity as to what will happen in the event of a divorce and reduce the risks of litigation costs. They are not legally enforceable, and so people say, well, what's the point about discussing them then? But the courts are invariably enforcing legal prenuptial agreements when all the procedures have been met, which means that people have to have independent legal advice. There has to be financial disclosure prior to entering into a prenuptial agreement. There has to be sufficient time, at least 28 days, between signature of the prenuptial agreement and the wedding. And the terms of the prenuptial agreement need to be fair. And I quite often see people come to see me who have been married and they're getting divorced, and I say to them, do you have, at the outset, did you have a prenuptial agreement? And they say no, and I sort of put my head in my hands, because I just think it would be so much easier and been able to limit their spouse's claims if they had entered into a prenuptial agreement. So the purpose of prenuptial
is to protect non-matrimonial wealth. What is non-matrimonial wealth? That means assets derived from inheritance or gifts, of your own personal hard work and endeavour before marriage. Non-matrimonial wealth is dealt with completely differently from matrimonial wealth, and it's not divided in the same way at all, and not touched unless it meets needs. So if you have parties who live in a matrimonial home, for example, that has been funded entirely from an inheritance or gift by one of the parties to the marriage, on a divorce, it's likely that, as a broad brush, that matrimonial home will be divided equally. And is that fair when most of the deposit has been funded, or the entire house has been funded from a source outside the marriage? So it's really important to think about how you want your assets to be dealt with in the event of big divorce. And the family court has really wide discretion on how to divide assets on a divorce. There's statutory guidelines in Section 24 and Section 25 of the Matrimonial Causes Act 1973, at which the main aim of the court is to achieve a clean break between the parties so that they can both become financially independent of each other, if at all possible. And in Section 25, the court will consider the needs of any children of the marriage, and the duration of the marriage, including cohabitation. Lots of us live together before we get married, and that period of cohabitation prior to marriage will be regarded as an end of the marriage. So you might have a long cohabitation and a short marriage,
but it will be regarded as a long marriage sometimes if the cohabitation has been extensive prior to marriage. Before we look at the health, the ages of the parties, and standard of living during marriage, and the financial resources of the parties, what sort of capital they have, and their income, and the contributions that each of them have made to the marriage. So they husband who stays at home and looks after the house and looks after the children, their contributions will be regarded as just as valid as a person who just goes out and burns money. Conduct, and this is very rarely looked at, and it has to be extremely bad, like attempt of murder, to be considered fair. Lots of people talk to you about their husbands being very financially controlling and being abusive, but it very rarely impacts upon how assets are divided on divorce. So the three key principles that the court will have is to ensure that both parties' housing and income needs are met, and that there'll be an element of sharing if there are surplus assets, and the court will give compensation in very rare cases. So the key case in relation to that sort of thing is the main case of Valentino, 2010 Supreme Court case, which ruled in favour of enforcing the prenuptial agreement and established that agreements should be respected unless fair, and that parties who enter into an agreement with independent legal advice once there'll be fair disclosure and the terms are fair and reasonable, the courts will enforce those prenuptial agreements because they will expect parties to have entered into the agreement knowing that they were entering into a legally enforceable agreement, and so people should expect to be held subject to the prenuptial agreement if they've had independent legal advice. But what cannot happen is that you cannot oust the jurisdiction of the court from looking at the prenuptial agreement, and spouses generally may want to challenge the terms of prenuptial agreement on divorce. But if the terms are fair and there's been financial disclosure and each party has had independent legal advice, then it's quite likely that they'll be held to the terms of the prenuptial agreement. So the Law Commission recommended in 2014 that qualifying nuptial agreement should be legally enforceable, but Parliament hasn't brought the legislation into effect yet, and it says that qualifying nuptial agreements were really legally binding if they're made by way of a deed, and financial disclosure has been provided ahead of the prenuptial agreement. Both parties, including independently legal advised, have signed at least 28 days before the wedding, and the agreement does not leave one party in real financial hardship, and neither party has been placed under duress, undue influence, fraud, or misrepresentation. Sometimes parties will say, well, I was put under some pressure to sign this agreement prior to my marriage, and therefore it's unfair. The cases say that that's not a real valid reason for getting out of a prenuptial agreement. An element of pressure is always there when you're entering into a prenuptial agreement, but provided you have independent legal advice, then it's more likely you're going to be held to the terms of the prenuptial agreement. Common challenges that we have as lawyers in relation to prenuptial agreements is an emotionally sensitive topic, and people will laugh and nervously. She said, well, how they won't break that conversation with my plus. But I think marriage is extremely difficult, and you have to be able to have a conversation, an honest and open conversation with your spouse about your aims. And it's rather like
whether you're both on the same page in terms of whether you want children together. I think you need to have a financial conversation about what you think is right and fair in the event of your breakthrough in marriage. I think it's important. I think it's a handy discussion to have. So it is an emotionally difficult conversation to have, but I think it's important that it's undertaken in any event, and that it helps if you're not having it only, right at the last minute. Quite often people will come to me and they say, well, I get married next week, I'm going to prenup agreement. It's really difficult to, well, it's impossible. You'll have to be having a prenuptial agreement or asking them to delay the wedding, because you have to have at least 28 days before signing the agreement and the wedding. Sometimes we're approached by parents of a child getting married, and they have obvious concerns about whether marriage is going to work out, and quite often you're having multiple people in the room giving you instructions. You're sort of having a conversation with the parents when the adult child is getting married, and they may have totally different approaches as to what they expect, what they want to be, and that's quite difficult. And therefore, as a financial planner, I think it's important to educate your clients about the need, when you're working with wealthy families, for younger generations to be aware that their wealth needs to be protected in the event that they're entering into a marriage. And sometimes, when you're working with very wealthy people, sometimes they have a draft prenuptial agreement that has been drafted many years before their children become slowly thinking about entering into relationships with people, just so that they can present it to the unsuspecting fiance and say, look, we've had this is part of our wealth planning as a family, we've had this discussion with our daughter many years before, this is not the case of thing. But you might smile, but actually I've been involved in discussions like that with families, and sometimes it's really important, rather than having a late conversation when it's too late in the day, when a couple have got so many things prior to the wedding going on in terms of planning their honeymoon and planning the day. It's really helpful to have this conversation early doors, and I would advise IFAs to have a really early conversation with their clients, thinking about what happened when you children married and how you like that sort of thing. And it's important to manage clients' expectations, because you have to balance the protection of the client and fairness to the other party. Because what cannot happen is that, sometimes I'll have a client come to me and say, well, I'm going to have everything that I brought into the marriage, and she can have everything that she brought into the marriage, but she may not have very much at all. She may not have a house, and any agreements that render somebody homeless without any which is fundamentally unfair, is not going to be upheld. And some people say, well, I'm never going to review this prenuptial agreement. This is a once and for all agreement, because our finances are not static, and it's important to review them every 3 to 5 years, to avoid what was a perfectly reasonable, fair agreement at the outset becoming, over the course of several years, unfair. So it's really important to have very frank conversations with clients who can be quite closed off and quite sort of, well, I'm not sharing this. This is not negotiable. Because sometimes you have to keep very, very, you have to think very carefully about what sort of home each party is going to be living in, especially if they have children together. And avoid last minute negotiations and planning well in advance. And sometimes there's a reluctance to provide transparent financial disclosure, and it's really important to people insist the prenuptial agreement if there's financial disclosure with documentation. Some people don't like doing that at all. Some people are ready to eat free, horrendous tools and have gone through the financial disclosure process. They really start to go through the same process again on a nuptial agreement. But it really, really helps if there's been an arm's length business type transaction in relation to the nuptial agreement negotiations. And a reluctance to provide sufficient capital or income to meet the needs of the forward party. Some people say, well, I'm not going to partner. I'm never going to pay spousal maintenance if it's marriage retinue. Well, she got a job and she can just go back to it. And that might be right and fair now, but is that going to be right and fair in 10 years' time? And there's children in the family and have any capacity isn't a factor because she's been at home lots of children. So it's important to review what commercial deals. And it's a bespoke document. I get weekly calls, not daily, weekly calls from people asking me how much it costs to have a prenuptial agreement. And they're bespoke documents because none of us have the same financial background, and it has to be tailored to each person's individual circumstances. And therefore we need quite a lot of information before we're able to advise people. But generally we're looking at between sort of £3,500 to £7,000 plus VAT that to get a pre-option agreement. People say, hi, that's a lot of money, especially when they're thinking of getting married, and that costs a lot of money as well. But if you think of the context of marriage and divorce, probably the most important financial decisions that you're ever going to make during the course of your lifetime, and it's important to protect yourself. So practical steps for clients are to start these discussions early and to avoid stress related to weddings, and be transparent with your financial disclosure. Consult legal professionals, real landlords, and sometimes that's quite difficult because I've had situations where I've had the parents ringing up how always they decided that their child is married and they don't protect family trust or family wealth in some way, and that give you quite strong instructions as to what you want with your client is their child. You have to take instructions, and sometimes there's a conflict between the two, so it's very important that you get clear instructions for your own client. And you need to consider future changes in circumstances. Are they in childbearing age? Are they likely to have children? Are they likely to have career changes, or they have cancer and they can't work? What would happen in those sorts of situations? And it's important to educate people to understand what a prenuptial agreement or a post-op agreement can and can't do, so that they understand the process. And quite often, the most effective way to protect from matrimonial wealth, the obvious ones, just don't get married. And then the second way is by having a discretionary trust that has been set up prior to marriage, doesn't coincide with the actual wedding date, because then you might need nuptial settlement get on the variation. But have a discretionary trust with a raft of discretionary beneficiaries that lends to purchase properties that may be a matrimonial home, and then income from the trust to repay interest and capital on a mortgage on the loan. So I've seen that working very, very effectively to protect wealth, and I think that's a really effective device. In relation to post-nuptial agreements after the wedding, and these are really popular as well. Like prenuptial agreements, they're not automatically legally enforceable, but if you highly dependent on your wife and there's been financial exposure, then expect to be bound by them. They are helpful over periodic review of prenuptial agreements, and they're helpful if there's insufficient time to sign a prenuptial agreement ahead of a wedding, and some people can't or won't
delay their wedding just to negotiate a prenuptial agreement. And so they sometimes get married and then they enter into a prenuptial agreement afterwards. Quite tricky because I was always advised the poorer party never to enter into a prenuptial agreement or a postnuptial agreement. But quite often people just say, well, I love this person and this is very important to them and this, I want to do it. And their postnuptial agreement can be used really effectively with the creation of a family investment company to then restrict claims by spouses who don't have any direct authority to the family company. It may have been set up, incorporated several years before the marriage of various family members who have shares in the company, and they get married, and it's really helpful when having postnuptial agreement. If you've got that sort of like family coming dynamic going on. So that's all I have to say about nuptial agreements, because
It's the cheapers.
Explains nicely reading whether the discretionary plus on that the chief thing. I'm Vicky, I head up the FICs team here at Myerson. I'm going to give you a quick overview and introduction to trusts. They've always been a popular tool, but I think given the recent autumn budget, there's probably more scope for using trusts, and a lot of people have been asking if help put trusts in place for them. Okay, so what is a trust? A trust is a separate legal entity, and it separates the ownership and control which sits for you trustees from the benefit of the trust. So we've got the beneficiaries who will benefit from it, that's been dealt with by the trustees. It's not too dissimilar to the structure of a company where you've got shareholders and directors. And think Andrew will go into a bit more detail about company side things when these structures on family investment companies. Who should set up a trust? I think we'd start with who can set up a trust. Adults over the age of 18 who is doing. Mostly we find it's parents, grandparents who want to plan for either succession planning, asset protection, so something James touched upon, and they one thing on its own is okay, but multiple things where you've got pre or post agreements, trusts and family investment companies, the more you've got, for the more rules tight it is. Providing for vulnerable beneficiaries, you might have children who, for example, I've got a nephew who's autistic, he's not going to be able to manage his own funds. He may be on these tested benefits in the future, you don't know. So there's usually a specific purpose as to why somebody you've got to set up a trust. What do you need to consider when setting a trust? First of all, purpose. There's usually some sort of purpose when you want to set up a trust. What do you want to get into it? Some people want to put in cash, some people want to put property. If you're looking at transferring property, you might want tax consequences when putting it into trust. Will they have enough? A lot of people want to save inheritance tax, you want to pay gifts. That's great, but don't forget this is a gift into a trust and you won't be able to get it back. So you want to make sure whatever you transfer, you're not going to need it. Plus, if you dip back into something you gifted away, it could be faster than giving reservation of benefits. You need to make sure that once it's gone, it's gone. Timings, when do you want to set up a trust? I'll go on to this in terms of timings later on. You need to think through before that in the budget. You know, if you know that if you gives age trusted to individuals in the last 7 years, falls outside those inheritance tax purposes. However, there have been murmurings, and again, we'll see what happens in the next couple of weeks. It could be, I've heard 10 years being something discussed. It could be extended to 10 years, and obviously the longer it is, the more difficult it is if you want to make gifts as early as possible. Trustees, who are even trustees going to be? If it's during your lifetime, you might want to be a trustee, so you can still control your assets and what you're going to do with it. If not, you might want to pass this down to the next generation. It could be your children, looking after the trust for their own benefits. You need a minimum of 2, maximum of 4, and these trustees are capable of administering the trust. They might be a professional person, they could be a financial advisor, they could be an accountant, used to dealing with this sort of thing. So these are really good things to be considering when setting trust. Tax consequences, you mentioned, depending on what type of trust, you've got income tax, capital gains tax, inheritance tax could be a factor as well. You can gift up to into trust £325,000, which is your red band. Anything over and above that will trigger an immediate inheritance tax of half the amount. It would be 20% on the surplus over £325,000. When set up a trust, as I mentioned, it could be on life, it could be on death, lifetime, and what to keep it as soon as possible. Again, we don't know if that's going to be bumped up in terms of time periods from 7 to 10 years. You might want to, for husbands and wives, we do this quite often for clients, each set up a trust with £325,000 in it, survive for 7 years, and later leave. This is good to start as early as possible. Obviously, later on in life, 18, 19s, or if you're in ill health, 7 years might not be achievable. So that's something we want to consider. You also set up trusts on death, and that's within your will. So you might get to do anything now to lock up any of your assets. Put this in your will. You can change your will at any time up to date to death, provided you've got mental capacity. And then, depending on what you're trying to achieve with that, there's different types of trusts you can use. Trust will often allow you to grow the value of assets outside of your estate, but benefit future generations. So it's a very good planning tool. There are lots of different types of trusts. I'm only listed them in 3 that we use most often. Bear trusts are the trusts where you may be a parent gifting properties to children who are under age. At the land registry, you can't put down somebody's name unless they're over the age of 18, so parents might be as trustees, holders and bear trusts for the child, but the asset is actually owned by the child. So if it happens to and they die, it will form part of their estate. Interest and possession trusts are another popular trust used, probably more often in wills than for lifetime gifting. It separates the right from the capital and income, used for maybe blended families. If you've been married, remarried, you've got a spouse, you want to provide for the spouse, you might want to say, James mentioned you can't leave somebody without a home, so you might say, we'll give them a right to income. So if there's a property, the income would be rent, you can live in the property rent-free, and that gives them a good roof over their head. Other savings and investments, it might be dividends, interest that they can have the right to. And then the capital is protected through what's passed in the wealth you've accumulated. Children will be passed on later on under the trust. And then the last one, the most flexible one, and I think the one James mentioned and a lot of people do like to use, is the discretionary trust. So the discretionary trust is set up so you've got trustees who make the decisions and decide who gets what, when, how much, if anything at all. It allows people to the trustees to look at the circumstances of the beneficiaries, their financial needs, how they're going to be payments to the beneficiaries. It could be an outright payment. Of course, if you do that, it adds to the value of that person's beneficiary's estate. You might want to do it by way of loan, which James also mentioned again. You make a loan to the individual, they can go and buy the house with the new spouse, but then you can charge interest on it, so there's some income coming into the trust, which you then pay out to others, for example, grandchildren. Okay. So a couple of reasons why you want to use the trust. Protecting reserving wealth we talked about, mostly for future generations. It can be protected against third-party creditors. Some people use it for care, and certain circumstances you can use trusts and not be classed as a declaration of asset for those care, and done well can also be used in divorce circumstances. Inheritance tax planning, I've talked about gifting either during lifetime or on death. Providing for beneficiaries, for the beneficiaries I've talked about where they can't manage their own funds, shouldn't have funds in their name, because they're either FICs or otherwise. Estate planning, we touched on blended families seem to be, more problems. So you've got an opportunity there to provide for all parties with less falling out. Flexibility, the most flexible one mentioned is the discretionary trust. You've got the opportunity for trustees to make decisions at that time based on the individual's circumstances, financial needs, and if it's on death, either looking at date of death or to do require at that time. Discretionary trust can run up to a maximum period of 25 years. He is going a long time. Most people run it for 1 or 2 generations and then decide to wind it up.
Thanks, Vicky. So I'm going to talk about family investment companies in overview, really. So the first question is, what is a family investment company? There's no real rocket science. It's a private company like any other, which is used to hold investments for a family. And a feature of that is that the company adopts bespoke documentation to meet the needs of the family. So key characteristics. So, as I said, private company. It could be limited or unlimited. I mean, you might use an unlimited company if there's an issue around confidentiality. You don't want to file annual accounts at company's house. But generally, private limited companies are the ones that are used. And the companies use to hold investments. And these could be, shares in private companies. They could be listed securities, portfolio securities, and property portfolios. I mean, we've done a lot of incorporation of buy-to-let portfolios, residential properties, and student lets. That's quite typical within a family investment company wrapper. So you can achieve a diversified portfolio of assets for the family. And the family investment company can also be used as a funding facility for other family entities or projects. A source of capital perhaps. And the identity of the shareholders, well, they're going to be different, people from different generations of the family, the senior generation, the children, perhaps even grandchildren. You might use trusts as well as shareholders, for example, where the children are under 18. A key feature of the family investment companies is its articles of association, and they'll need to be created in a bespoke way to suit the requirements of the company, of the family. And as part of that, what tends to happen in family investment companies is you create different classes of shares, and different family members will hold different classes of shares, and maybe with varying rights attached to different classes of shares to create the required outcome for each shareholder. So you might have alphabet shares, but at the heart of it, the rights on shares are the ability to vote, the ability to receive a dividend, and the right to a return of capital. And you can vary those rights within different classes allocated to different family members to create the required outcome. So, for example, the senior generation might want the voting rights to have control. You might want the younger generation to have more of the capital rights. So that you're doing inheritance tax or family wealth planning in that respect, but you can really create a bespoke arrangement. You could create preference shares, for example, where you want to pay dividends, where certain shareholders have a preferential right to dividends over other shareholders. Or you could go for freezer or flowering shares. That's where you can sort of allocate the growth in value of the assets and channel that towards some classes of shares, but not others. So perhaps you want to channel that value away from the senior generation to the younger generation. Another key aspect is the board of directors. So typically, in private companies, the shareholders delegate the day-to-day running of the company to the board of directors. So you need to think about who those directors are going to be, and typically they're made up of family members. So why use a FIC? Well, FICs are subject to corporate tax rates. which are often lower than personal tax rates. This means that more capital is available for reinvestment, which accelerates wealth accumulation over time. But more importantly, FICs are used to manage succession of wealth in families and undertake estate planning. So the key element here is minimising the exposure of the senior generation to inheritance tax. So typically, the initial funding is provided by the senior generation, the initial funding of the FIC, and the senior generation retain control, so they'll get the voting rights, and the wealth is passed to the next generation by way of gift. Now, of course, this is where the 7-year rule comes into play. So as long as that shareholder, that senior shareholder, survives 7 years from the date of the gift, then there's no inheritance tax. So I'm saying there, so typically a gift from the senior generation would be implemented either by issuing shares to all family members on incorporation at nominal value, that's incorporation of the company, or shares can simply be transferred by the senior generation to the next generation.
Sorry, can I ask a question?
Yeah.
If you do that, does it not spark a capital gains tax?
Well, again, I'm not a tax advisor, so I'm really just talking about the flexibility of the different share rights that you can put in place, and well, you structure it as a gift, but you need to take tax advice as part of this planning. So the circumstances will vary from family to family. As I'll come on to in a later slide, tax advice is key to whatever you do. So another advantage of a FIC is a separation of ownership and control. So as we discussed in the previous slide, you've got the shareholders owning the shares, and you've got the directors managing the day-to-day issues in respect of the company, and so that gives you flexibility in terms of the way you manage the company's affairs, and you can create tailored arrangements to suit the family members. Another advantage might be that on death, a senior shareholder might only hold a minority interest in the company, i.e., might hold less than 50% of the shares in the company. So when you come to value those shares, you might be able to apply a minority discount to the value of those shares, which thereby brings down the value of the estate. Another advantage is the payment of dividends. So you could have different dividend rights on different classes of shares. You can even have differential dividend rights, whereby the directors can, when they declare dividends, they can pay dividends on one class of shares, but not on another. So that introduces flexibility. And there's also the protection of capital to think about. So the directors retain control over how the capital is invested. And due to the corporate structure, the capital is not easily realisable, which is an advantage where families are keen to preserve capital for future generations. So in terms of all the shareholders of the company, they're all members of the same family. So you've got that promotes a collaborative approach between the different generations, and also introduces the younger generation into wealth management and thinking about the family's wealth, getting them involved. So it creates a shared framework for making investment decisions, and in this way, a FIC can become akin to a family office, providing wider support to family members and establishing wider principles within the family for managing the family wealth. So I just put this slide in really just by way of illustration. So you've got your family investment company in the middle there, and on the left you've got the senior generation introducing a loan into the family investment company. You've got the repayment of the loan, which is a good way to get money out of the company because it's tax efficient. And then on the bottom here, you've got the investments held by the company, and then the wealth distribution to shareholders. I mean, it depends what the strategy of the family is, but it might be the senior generation need the income from the investments to provide them with income to live on. So you might provide the senior generation with dividend rights in that scenario, or it might simply be the FIC might simply be a place to park assets and to grow the wealth over time as those investments appreciate in value. So as I was saying at the beginning, as a response to your question, so when you're looking to set up a FIC, the first thing you need to do is take tax advice, because the FIC is it's the reason for adopting a FIC is for tax reasons, really, for tax efficiency, I think primarily. So tax advice is essential. It may be that a FIC isn't appropriate to any particular family's circumstances. It may be that it is, but tax advice is essential as a starting point. So broadly then, you incorporate your family investment company. You need to think about the articles of association, as we discussed earlier, the rights on different classes of shares, what you were trying to achieve, the composition of, and again, then I'll talk about the composition of the board. You need to make sure that the key decisions are made by the right people. But again, you might have a situation where the senior generation want to retain control over the assets. Therefore, they'll have the voting rights, or most of the voting rights, and they'll have control over who's on the board, who's appointed, and who's taken off. Then a key aspect, of course, is the funding of the FIC. How's it going to be funded? It could be simply a share subscription for cash. So you introduce cash in return for shares, or it could be a loan. Again, so the repayments of a loan are tax efficient. Again, probably a loan from the senior generation. Or as we've seen a lot of the property incorporations we've done, it could be you transfer assets into the FIC, like a portfolio of properties, buy-to-lets, in return for shares in the financial in the family investment company. So just a few concluding thoughts, really. I mean, a company is not an alien concept. The way a company functions in terms of the ownership and the management of a company. To many business-minded individuals, it's not, as I say, it's familiar, so it's attractive in that way. It's also, a flexible structure, as we've seen on dividends, on voting, on control, and on the allocation of capital between shareholders. But it's very much part of a long-term financial planning. I think that's the way it should be looked at for families over generations. And I think, the FICs are becoming more popular. We're certainly seeing a lot more work around financial investment companies. And, lots of the commentators are saying that as well. And I think, just look at the recent budget with the changes to, as Vicky mentioned, to agricultural property relief, business property relief, the erosion of those reliefs for inheritance tax. More and more people are going to be looking at financial investment companies as a solution. So I think they're going to increasingly be popular in the future as well. So that's all on family investment companies. If you have any questions, we're all around at the end, so please feel free to come and speak to any one of us.